Should I write my own estate plan? Hi, I'm Gary DeWitt from the DeWitt Law Firm. We do estate planning, we do probate, and we do them well. If you have questions about this or anything else, you can set up a time to talk to me for free on the phone or in person by going to planwithgary.com. The problem with estate planning mistakes is they're often discovered too late. Your plan needs to be based on tried and true techniques and methods. The internet has a wealth of data, but often a lack of good information. Why do I say data? Data is raw. Information is data made useful. You need to be careful when you search the internet for estate planning information. You'll find a lot of general information that may apply and some state-specific information. Often the state information isn't labeled as state-specific and you may think it applies to you. You'll find articles that say probate isn't bad, and it isn't in some states. You'll find articles, one of them will say X is the truth, and the other one will say Y is the truth, and which one is depends on where you're at. You should be careful and consult an attorney familiar with your state's laws before you start your plan. The Florida case of Aldrich versus Basile illustrates this problem quite well. Ann Aldrich wrote her will on an easy legal form. On that form, she left a list of property to go to her sister, Mary Jan Eaton. She also wrote, "If Mary Jan Eaton dies before I do, I leave all to my brother." Containing no other distributive provisions, the will was duly signed and witnessed. The will did not contain a clause to take care of the rest and residue of the estate. It made specific gifts of specific property only. This is a mistake that is easy to make. 3 years later, Miss Eaton did die before Ann Aldrich, becoming her benefactor instead of her beneficiary. Miss Eaton left cash and land in Putnam County to Miss Aldrich, who deposited the cash she inherited from Miss Eaton in an account she opened for that purpose. On October 9, 2009, Ann Aldrich herself passed away, never having revised her will. After inheriting from her sister, she did leave a handwritten note, possibly an attempt at an amendment to her will. It says, "This is an addendum to my will, dated April 5, 2004. Since my sister, Mary Jane Eaton, has passed away, I reiterate that all my worldly possessions pass to my brother." The note was signed and witnessed by her niece. However, her niece was not a disinterested party. The court ruled this was not a validly executed amendment to her will. So the property Ann Aldrich inherited from her sister was not added to her will. Technically, she died without a will as to the property she inherited from her sister. Ultimately, her nieces inherited a portion of the estate. A concurring opinion by Justice Parente sums it up well. While I appreciate there are many individuals in this state who might have difficulty affording a lawyer, this case does remind me of the old adage, penny wise and pound foolish. Obviously, the cost of drafting a will through the use of a pre-printed form is likely substantially lower than the cost of hiring a knowledgeable lawyer. However, as illustrated by this case, the ultimate cost of utilizing such a form to draft one's will has the potential to far surpass the cost of hiring a lawyer at the outset. In a case such as this, which involved a substantial sum of money, the time, the effort, and expense of extensive litigation undertaken in order to prove a testator's true intent after the testator's death can necessitate the expenditure of much more substantial amounts in attorney fees than was avoided. I therefore take this opportunity to highlight a cautionary tale of the potential dangers of utilizing pre-printed forms and drafting a will without legal assistance. If you have questions about this or anything else, you can set up a time to talk to me for free over the phone or in person by going to planwithgary.com.